welcome everybody to Brexit, the Known Unknowns seminar this afternoon, or rather webinar. Just to say to everybody listening, first of all, thank you very much for attending. Secondly, we are recording this, so I've just said to the speakers, the panelists, it's great. They can show their children during the Christmas holidays. What an amazing gift to give. And we are having questions and answers on the Q&A function, so that will be able to do that. So without further ado, I'd like to introduce everyone. I'm delighted to be here today to talk about a very tricky subject in so many areas, and no less so in family law. I'm joined by good friends and family lawyers from London, Paris, New York and Switzerland. We will attempt to talk you through the minefield that is Brexit. Anyway, we are 10 days from Christmas and apparently 16 days from Brexit, apparently. It struck me that there are similarities between the two big days. Some people are very excited and others are dreading it. I won't make any jokes. Safe to say that Christmas dinner may not be the same this year without Brussels. So, what I'd just like to also just do a shout out for Tim Whitney, who is one of the principal associates at Mills & Reeve, and he is head of the international group, and he was the one who suggested this webinar. So shout out to Tim, well done. On the 1st of January 2021, family lawyers will see arguably the biggest change in family law in 20 years in international family law. A whole generation of family lawyers have only really known one system, which has been dominated by the EU regulations. These regulations will disappear on the 31st December at 11 p.m, and this will create an abundance of issues and new case law for practitioners, the courts and clients. Perhaps it's good to reflect at this point about the huge geographical changes there have been since we joined the EU. Now there are 3 million EU citizens living in the UK and 1 million UK nationals living in the EU. As you can imagine, this means that many of our cases have international elements, and so we really need to get to grips with what Brexit means for us and our clients. So perhaps to start, back to basics. At the moment, in the UK, we're in a treaty with the EU, which basically says that if two countries have jurisdiction for divorce and financial arrangements, then the country who wins the race is literally the first past the post. The country where the first divorce petition is issued wins. This has led to us family lawyers in England and Wales having outdoor clerks who are good at running, so they can get to the court first and they can get the court date and time stamped on the divorce petition. Enough from me. I would now like to introduce Daniel Eames, who is often described as the guru of EU law. Daniel and I worked together for many years, and we both had a keen interest in EU law and were, frankly, I would say, rather nerdy. Daniel is now a partner at Mitchell Moore Solicitors and spokesperson for Resolution on Brexit. He's the chair of Resolution's International Committee and one of the editors of the Red Book, specifically on sections on international divorce and maintenance. I asked Daniel what his highlight of 2020 was, and he told me it had been a truly terrible year, and therefore his highlight was changing firms and joining Mitchell Moores. Well, well done and congratulations for that, Daniel. So some questions for you. Just starting off from an English point of view, how will the system change now for issuing divorce proceedings, and what does this mean for clients?
Thank you for that introduction, Suzanne. Yes, it has been a difficult year, but yes, I've come out and kept going, so it's okay. In terms of how things are going to change, as you've already outlined, Suzanne, at the moment it's first to issue, who gets there first, and that's going to change with the end of the regulations. And as between England and the other EU member states, in terms of the English perspective, it will be a question of forum convenience from an English side. So as long as you have jurisdiction in this court, in this country, to bring divorce proceedings, then the English court And it's not, obviously that's not the end of the story, but for the English court side, we get to decide whether we think we're the appropriate place to deal with this. Now, of course, in an English, say an English-French situation, so to say two French nationals living here, they have a choice at the moment. Do they get divorced in England or in France, which is the best jurisdiction for that person? But going forward, you could have proceedings in both jurisdictions. So you can have a divorce in France, divorce in England. Won't necessarily matter in terms of jurisdiction who issues first from an English perspective. The English court will say, well, we think it should be dealt with in our country. And obviously the problem then arises in later parts of the proceedings when you come to recognise, and we'll come on and talk about that, recognise your divorce or your financial order, because the French court might say, well, we were first, we're not going to recognise your divorce or your financial order.
So does that mean it could be more expensive for clients?
Certainly more expensive for clients. It's, I mean, as you explained at the start, we haven't really known any other system as English family lawyers, certainly in terms of the EU. And so cases will be more expensive. Before you get into what sort of orders the English court should make, there's going to be a very lengthy hearing about which is the most appropriate court. So yes, more expensive, a very steep learning curve for us all, and definitely bad for clients.
Thank you. And what about the whole issue of maintenance, which is incredibly complicated? And I'm going to ask you a really difficult question now. Can you boil it down to just a few nuggets to give us the takeaways? What do we need to know?
So, I mean, the position with maintenance is similar to divorce. At the moment, it's first past the post. If you issue your maintenance proceedings in England first before, say, France, then the English court will deal with all aspects of maintenance. But maintenance is complicated because it's not just a monthly maintenance payment. It could be a lump sum for housing. It could be an order to transfer a property. And so it's not just about those monthly payments. It's much wider than that. And so again, it will be for the English court in its mind to decide which is the most appropriate forum. But again, we'll have the same problem if the French court is first and is dealing with maintenance already as part of its divorce proceedings. Then again, it's open to the French court to refuse to recognise our orders. I mean, the key thing as well is that the jurisdictional provisions, I don't get too technical, but the jurisdictional provisions have changed for England and Wales. So you have to have different grounds depending on the type of maintenance. So different grounds for child maintenance, different grounds for spousal maintenance. And there's still the possibility for the divorce to be dealt with in one country or the maintenance to be dealt with in another. But then you've got the problem that you could have two sets of proceedings, two different decisions about which is the most appropriate court. So it is an absolute mess, I'm afraid, and going to be more expensive and more difficult for clients.
And anything in particular in relation to pensions?
Yeah, pensions is a really tricky one. So say you've had a US divorce, neither party is currently resident in England and Wales, but perhaps the couple lived in England for a while, but they're both US nationals. They get divorced in the US, and the US court might say, well, this is how they should deal with their pension. And at the moment, we have a special provision under the maintenance regulation, which is the regulation that deals with maintenance claims, that if no other country, so it's called a forum of necessity, if no other country can deal with maintenance, and in this case it would be dividing up a pension, then the court where the asset is based can deal with that. So at the moment, if you've got a US divorce, US nationals, no other connection with this country other than once upon a time they generated a pension in this jurisdiction, then the English court can deal with that. But on the 31st of December, that goes, and they either would have to move here or become a UK national in order to share that pension, or get good US advice from someone like Gretchen and make sure that they've offset or dealt with that properly in the New York divorce before they have to deal with a pension in England.
Yeah, and you've touched upon recognition of divorces and enforcement. Again, another really tricky subject. Can you make that sound simple?
I'll do my best. I mean, just going back to the point you said, Suzanne, about race to issue. Well, there may not be a race to issue anymore, but you might be on a race to decree. So let's say divorce is in France first, we're second, but if we get our divorce first, then will the French court recognise that? And there is a replacement convention, Hague Convention, that deals with divorce recognition, but really unhelpfully, France, Germany, Spain, I think up to 15 EU member states are not party to that convention, so it will be dealt with by their national law, and it may be that Rahima will come on and talk about what the French court will do in this situation. But yes, we've got the situation where the divorce may not be recognised. If you've got two foreign nationals living here who may want to go home to their home country at some point or remarry in their home country, well, will their English divorce be recognised? That's a real problem. And so the real key message for everyone is take good foreign advice early, because if your divorce is not going to be recognised, what is the point in winning the forum battle? If your maintenance order is not going to be recognised, there is no point in having those arguments. So it's really, really key before anybody. I mean, we all should have been doing it before, but it becomes even more important now, because first to issue does, because at the moment first to issue means your divorce gets recognised, your maintenance order gets recognised, but that will all change, and there's provision for the other countries to refuse to recognise.
Yeah, really, that's great. Thank you. And one of the other things that we do a lot of, and I'm sure everybody on this call does, is prenups. Is there anything specific that we should be thinking about now for clients in relation to prenups?
Not very romantic, but good news on the prenup side, I think, because at the moment you can't, in a prenuptial agreement, say which country deals with the divorce in terms of an EU situation. But certainly from an English perspective, if one of the parties have said that the divorce should be dealt with in France or Spain or Germany, wherever else, then that's definitely a thing that the English court would take into account when looking at a forum dispute. So that's definitely some planning that people can do and will improve the situation, you know, in terms of asset protection.
So in a huge mess, there's one positive, which is brilliant.
Yeah, there are some other winners, but it's technical. Very technical. You know, there are some other examples where people will benefit. Varying maintenance orders may become easier for a variety of reasons. But yes, you know, they're generally, the message is, you know, that it's going to be more complicated for clients, more expensive, and as I say, the lawyers have got a very steep learning curve, and their advisors. You know, the people advising them on their financial situations. It's going to be much harder to give good advice at the moment, I think.
Thanks very much, Daniel. I'm now going to turn to our closest neighbour, and that's Rahima. So both geographically and the number of French people who live in the UK, I think we should be considering France next. So it's great to introduce Rahima. After practicing as a family lawyer in Canada, a country with a dual legal system, common and civil law, Rahima joined BWG in 2005 and became a partner in 2015. A true, and I love this, citizen of the world. She's binational and trilingual. She's sensitive to cultural differences and has an affinity for foreign legal systems. She's an active member of various international organisations, such as being a fellow of the IAFL, officer at the Family Law Commission of the IBA, and many other things. Rahima is known for her tenacity and integrity, and is recognised as a true support in accompanying her clients by helping them to resolve their family crises. And I asked Rahima about her best memory of 2020, and that was her last trip to NYC, Gretchen, and that was at the end of February 2020. So not much travelling since then. Rahima, we've been talking about things from an English point of view, and Daniel's been referencing France. It'd be really helpful from your perspective as a French lawyer if you could explain how you see the situation now that we are Brexiting.
Thanks very much, Suzanne, for the intro, and hi, everyone. Yeah, I totally agree with Daniel. It's going to be more complicated, and for the clients, they would need to go and seek for advice. It was already the case, you're right, Daniel, but with what is coming, it's I think the best important thing, because as you said, what is the aim of having a beautiful judgment of divorce if it cannot be recognized and enforced? So here we all need to work more and more together for the sake of the clients to see where they should go first. As far as French is concerned, I need to tell you by an intro that we're very, very sad in France about the Brexit. for many reasons. But anyway, we will have to deal with it. So as far as divorce is concerned, about jurisdiction, whenever there is a foreign element in front of the French judge involving the UK, once the French court will be seized of divorce proceedings, we are going to continue to apply our Brussels 2A, Brussels 2bis regulations on jurisdiction and our famous Article 3. The main changes will be that we will be able to use additional grounds of French jurisdiction based on Article 6 and 7 of Brussels 2A. Why? Because actually, if no member state has ground for jurisdiction, and the UK will become a non-member state as of 1st of January, then as a subsidiary manner, the French judge will be able to accept its jurisdiction in many cases, and we are going to look our internal French law, which says that if one of the spouse is an habitual resident and that he's living in France for 6 months, for example, or 12 months if he's not a French citizen, then the French judge will still have jurisdiction over the divorce. And otherwise, we still have our Article 14 and 15 of the Civil Code, which are based on the French nationality, which is different from the domicile, but the main changes on the jurisdiction of divorce is that we will have many more possibility of the French judge keeping his jurisdiction over divorce. As far as the applicable law is concerned on the divorce, you know that the French judge will still apply Rome 3, which is a regulation on applicable law. And here, no change. What you should know, but this is already the case, you know that Rome 3 is has a universal application. So if we're in front of the French judge and Rome 3 designate UK law to the divorce, then the French judge will have to apply UK law. I know that many countries, and I know that in the UK judge will never apply a foreign law, but we do that in France. So we will still doing that, and so there will be cases in which we will still apply UK law. All right. Regarding the recognition and enforcement, the only difference is that an English decision of divorce will no longer be eligible to the European certifications. So we would apply our internal French law on recognition. To reply to what Daniel said, although it's true that France, unlike the UK, is not part of this Hague Convention of 1970 on the recognition of the divorce, you need to know that our French Supreme Court rules by saying that the pronunciation of the divorce itself will be automatically recognized. So here you will see, and I will come back to that on the list and on the race of jurisdiction. I think we will still do have race of jurisdiction, and what we know by experience is that the proceedings are going faster in the UK than in France. So there would be situation in which both countries would have jurisdiction, and then it will be for me no longer a race for jurisdiction, but a race of recognition, and who renders the decision first, actually.
Yeah.
So that's it for divorce. On maintenance, it is still complicated. It is always complicated, but for France, we would still apply the maintenance regulation, the European maintenance regulation, Article 3, and nothing will change for us on that part, on jurisdiction. On applicable law on maintenance, we will still continue to apply the rules set up by the Hague Protocol of 2007. I think there is, but maybe Daniel can confirm that the UK is asked to become part of that Hague.
Yeah, and the Hague have already agreed. Yeah.
Okay,
yeah.
So for us, no change in that. And what else I could tell you about the lease pendants, but you already, Daniel, you already explained the difficulty we will have. For the French judge, he will still apply Article 19 of Brussels 2A for the lease pendants regarding the divorce, or Article 12 of the maintenance regulations. No problems with that. The problem is that it will no longer apply between France and the UK. So what we think is that if the English courts are seized before the French court, then an exception of lease pendants will have to be raised in front of the French judge. And if this exception is upheld by the French judge, by the French court, then the French will have to stay the proceedings. It won't change for us, and then it will have to decline its jurisdiction to the UK courts. However, if French is seized before the English judge, and this is what Daniel already explained, then the English court will be able to accept, nevertheless, its jurisdiction for foreign convenience, and there is the complication, because it will be possible, I think, to challenge the enforcement of this English decision in France. But now we need to wait and see what's going to happen. But it's true that it's very sad in a way that when we did have all this EU regulation for the clients, it was more easy, because even for us, we were able to advise them properly. Now it's, as you said, the totally unknown. We don't know what is gonna, and for the clients, yeah, it's gonna cost more money.
I totally agree. So that's why we called it the unknowns. And on the chat in the Q&A, there's lots of comments about how people don't want us to leave, and we don't want to leave. So we are we're the reluctant Brexiteers, or the moaning Remainers, as I called us the other day, because we absolutely don't want to leave. Daniel, did you want to come back in?
I was just going to pick up a couple of points that Rahima made. The first one is a really important one, and it sounds very technical. What is the applicable law? Because at the moment, the English court only applies English law, but the other EU member states, or many of the other EU member states, will apply English law. So again, that begs the question, why are we having a battle about which is the most appropriate place if the French court in certain situations will apply English law? So that's a key thing for people to remember. And I think most lawyers are aware of that, but it's a really key point. The other issue that Raheem has raised is in respect of the Hague 2007 Convention. There isn't actually really much change in terms of outgoing English orders, but it's going to be more difficult to enforce a French order in England now, because they're not automatically enforceable anymore. So on the French side, that's going to be more difficult.
Yeah, thanks very much. Well, we're now turning our attention to New York and Gretchen, and that's because effectively, at least in the interim, Gretchen, perhaps not for the long term, but at least in the interim, we're going to be treating Europe in many ways as though as how we currently treat New York, with having sort of foreign convenience. So I thought it'd be really good to hear from you about how you have dealt with your cases, therefore, on that basis. So Gretchen is a partner at Cohen Rabin Stein Schumann in New York. A significant portion of her practice focuses on cross-border matters. She's active in the IFL and is president of the New York Women's Bar Association Foundation. Now, again, Gretchen, I asked you about your favourite memory, and I know, of course, that you've got 4 children, and yours was your kids using the bathtub as a pool, which I just love. I've got this vision of New York now, so that's perfect. So if you could tell us a bit more about the situation in New York, that would be really helpful.
Absolutely, Suzanne. Thank you so much for that lovely introduction. I know it's been a very difficult year for everyone, and I think the world is changing, especially for everyone in the United States with the change of the administration and with the vaccine. And hopefully we have a lot of good things to look forward to in 2021. New York is very similar to the English approach. We don't have Brussels. Our divorce jurisdiction focuses exclusively on residency in the first instance, not domicile. We have residency requirements, but under the law of New York, it is possible to have residences in multiple places. So what does that mean? Under New York law, if you have an international couple with a residence in London and in Paris and New York, you could have 2 or more legitimate divorce jurisdictions. So the next analysis that the court would turn to is, first of all, who is first in time in terms of filing? That is a substantial factor. The conventional wisdom was in the past that the first complaint served would carry the day. Now we're seeing some writing by Justice Sunshine out of the Brooklyn courts. He's the chief judge of the state that in fact perhaps first commenced will carry the day. But that's not the end of the inquiry. The court could move on to a forum nonconvenience analysis, and we have a specific statute that allows our courts to look and see what would be the preferable forum. And in that instance, it's actually a very heavily fact-specific analysis. The burden is very high. The defendant must make a motion to have the court consider the forum nonconvenience argument and to stay or dismiss the New York divorce proceedings. And the court will look at things like the potential hardship on the defendant, the burden on the New York courts, the unavailability of an alternative forum, whether both parties are New York residents, and also whether the case has substantial nexus to New York. And when I say these are very difficult cases to win, they're very expensive. As Rahima mentioned and Daniel mentioned, you have parallel litigation in both jurisdictions. You have the cost of motions, the cost of potentially a trial on the threshold issues. And, you know, there are a lot of times where we can't avoid these instances because maybe we don't have a marital agreement that specifies the forum, and I'll get to that in a moment. But in particular, I also think that it's quite interesting to consider the hardship on the defendant, because now with everything moving to virtual trials, there's literally no hardship or little hardship, if any, to appearing virtually. And in fact, we have lawyers that are appearing from different states and different countries and different parts of New York and conducting trials at home and not from their offices. So to me, I think that's an important piece of our law to see how that evolves in the future. I don't think that the virtual hearings will be retired once the pandemic is over. And I think they'll be used much, much more in international proceedings. So with regard to New York law, I will mention that one caveat is we have separate international and interstate custody and child support laws. So those particular set of statutes would also control jurisdiction separate and apart from the divorce. And like the point that Daniel had made, in New York, it's very possible to have the dissolution proceedings and the financial proceedings as part of the divorce. in New York and to have the child custody and child support potentially litigated in a different jurisdiction. And in some cases, that may even be preferable. And I'll also state that our UCCJEA, which is our interstate international custody statute, has its own specific provisions for forum nonconvenience. So even if New York is the home state of the children, which means that the children resided here for 6 months with a parent prior to the filing, New York could still send it to a different or foreign jurisdiction if in fact it felt that under the forum nonconvenience provisions of the custodial statute, that would be the appropriate way to handle the matter. With regard to forum selection clauses, oftentimes there were questions raised about prenuptial agreements. And most certainly, in addition to a choice of law clause where I have international couples, I will often consider a forum selection clause to have an exclusive place to litigate divorce-related issues. And in fact, the New York courts are very specific in enforcing those. There was an appellate case from 2014, Ofer versus Sirota, where the wife argued that the wife was Israeli. There was a choice of an Israeli forum for any dissolution proceedings in the prenuptial agreement. And she argued that, it would be a very unhappy result in Israel. And in fact, she wanted to proceed in New York. And the court said, no, having a better or worse resolution is not a factor in the analysis. You have an enforceable forum selection clause. You understood what the selection clause meant when you signed the prenuptial agreement, and we are going to make you litigate in Israel. So New York is very, very strong in terms of both choice of law and choice of forum clauses. And I also think that it's important to have the choice of law and the choice of forum in most cases dovetail with each other, so that you don't have the litigation about where any dissolution proceedings would be litigated. And you also don't have, I think there's more risk in terms of having a foreign court misapply the foreign law if you're not, let's call it, I guess, in the home place.
Brilliant. Thank you very much, Gretchen. Absolutely fascinating. And I love the idea of Justice Sunshine in Brooklyn. I feel as though I want to move there and appear in front of him or her. Sounds fantastic. So we're now moving on to Switzerland. And in a way, Switzerland is going to be like we are now, which is sort of in Europe, but not in the EU. And with Switzerland, in legal terms, they deal often with the Lugano Convention. And although we haven't signed up, we're not a party to the Lugano Convention yet, I think the wisdom is that we're likely to in the next 6 months or so. So I thought it'd be really good to hear from Magda about Switzerland and how they deal with their situation. Magda is a Swiss lawyer practicing in Geneva for the last 19 years. They have a lot of expats living in Geneva, so she's really familiar with the private international law. And Magda's best memory of 2020, which is the same as mine, Magda, was skiing in the French Alps with her children in February, absolutely carefree, doing what they liked most without realizing that they were on the verge of a pandemic. I know exactly what you feel. So Magda, if you can tell us a bit more about how things are in Switzerland, because that's where we are right now, I think.
Yes, absolutely. Thank you, Suzanne. As Switzerland was never part of the EU, I think I have an interesting story to tell you, to give you a little insight of how it looks to live like an outcast. I would say that I remember when I was a teenager in 1992 and Switzerland refused on the voting to join EU, I was desperate because in my teenager's eyes, it was a loss of opportunities. And I have to say, like years forward, the position of being an outcast is quite comfortable. In fact, we have surveys showing consistently Swiss people are really happy with the bilateral route. And it's true, and I suppose that now that every big negotiation with the EU is quite stressing because we are, compared to UK at least, we are a very small country, but the results at this date were honorable, and I hope you won't ruin that for us. But as for now, we are able to be quite active on the international divorce market, and we are happy with that route. I just assume that for UK lawyers, like it is for us, it's going to be a little shift in the practice because we are used, you know, to check when you have just like a state that's concerned, whether we have a special convention with that state, and it's not that an uncontrollable matter. We have just like 3 topics to check: jurisdiction, applicable law, recognition and enforcement. You have to learn about shopping up the subject. Like in New York, we don't have the same courts, for instance, for maintenance, child support, parental rights, divorce and liquidation of the asset. So it boils down to the fact that you have like 3 topics to check with 5 matters. It's just like 15 items to check before giving a sound advice to a client. So you will manage that. I'm sure you're going to be very good at it. Now, on a more practical level, what will it change with our relationship between Switzerland and UK because you go out of the Lugano Convention? I would say that unfortunately, it won't bring us a lot of new divorce opportunities. And why do I say that? It's just like if you cannot use anymore the Lugano Convention for recognition of maintenance, for instance, you fall back to the good old convention, Hague Convention of 1973. The grounds for jurisdiction are the same. So nothing special for practitioner. It's useful to know that for provisional measures on maintenance, you can use that convention to have it recognized and executed in Switzerland. So it's almost the same. Same thing for jurisdiction. If you're not able to use the Lugano Convention anymore, you fall back to the good old private international Swiss law, and you have the same grounds for jurisdiction. So I would say it's rather for us a non-event. But you know, if you have a case in UK with Switzerland, let it be because you have some assets in Switzerland. You know, we love chalet, we love just like bank accounts, you too. So as a lawyer, you have like 2 options. You have to think whether it's more interesting for a client to go in front of the UK judge to get an order and to have it executed in Switzerland, or if it's better to go directly in front of the Swiss judge. And on that topic, really on a Swiss perspective, of course, I would say that it's more interesting and probably safer and cheaper for your client to go in front of the Swiss judge directly, because we have a provision that allow your clients to get in front of the Swiss judge where some assets are, to have any conservative measure. Of course, it has to be proportionate, it has to be necessary, but you have to, you can get all the conservative measures to secure any financial claims arising out of a marriage. So it's a very large scope that you can use for your clients. And so you can get in front of a Swiss judge, for instance, a freezing order until you have your foreign divorce judgment on the liquidation of the asset. So you are really at peace, you're comfortable, you just sit and wait. And we even have, like in 2017, in front of a highest court, we had an order that gave us a freezing order until the spouse claim on liquidation of the assets was paid, fully paid. And that's absolutely royal. You see it, you're sure to be paid. So that's absolutely comfortable. You can also have just like, we have frozen chalet in Verbier because there was just like a UK divorce pending in front of the London court. So you can get that even if the divorce is not happening in the UK. Or for instance, on a Friday night, we knew that the spouse was transferring big chunks of money out of a foreign bank account to a Swiss bank account. And on the Monday morning, we had a freezing order of that Swiss bank account. So you have to know that as Swiss, we were quite protective of our banking secrecy with not a lot of success, but we try to keep that. So you will never be able to have fishing expeditions, of course not. You have to be able to know where the assets are, but as soon as you have that info, and I think that in front of the UK court, you are kind of transparent for that, you can get it freezed in Switzerland. And there's also 2 things that brings my attention. First of all, perhaps going in front of Swiss court is interesting when you need to keep the surprise effect. Of course, you don't want the debtor being able to get rid of those assets, to transfer them elsewhere. So going in front of the Swiss judge will allow you, on certain conditions, of course, for having super provisional measures, which means before the opponent is even being heard. So you have that judicial order to freeze the assets, or you have another thing that's very, very useful about maintenance for practitioner, because we all have the same problem. You know, you have to wait until there's a lot of arrears. So it's financially interesting to acting against a debtor. But if that debtor has an employer in Switzerland, he doesn't even have to live there. Or if he has a tenant that has to pay him some rent on a regular basis, and you're able to show to the Swiss judge that he's not respecting the financial order, you can get the Swiss judge having the employer paying you all the future alimony. So that's really great for our clients. So you see, in the relationship with the UK, we have a lot of means to help you out. Now, Suzanne, you asked me a question. What would I do if I had a magical wand? And I want to answer that because you all talk about a race for jurisdiction. Unfortunately, in Switzerland, we lose that race all the time, because if you want to file a divorce in Switzerland, you have to wait. You have to be living separately for 2 years before being able to file. And that doesn't make us very competitive. And I would like us to become a place to be for divorces like UK. Thank you.
Thank you very much, Magda. So interesting. And you've made Switzerland sound so compelling in every way, not only living there with the chalets and stuff like that, but also the way you have your freezing orders. And before we move on, I just want to say it puts me in memory of a client I once had. I got a massive freezing order, and the client said to me, Suzanne, I need you to defrost my husband. It's causing him too much pain. And so from now on, I say, would you like a defrosting of the freezing order? I love it. We need to defrost the husbands. So moving now, we've been talking very much about money and finances. We're now going to turn our attention to discussing the situation regarding the children. And I'm delighted to welcome Zoe Fleetwood, who's recently joined Mills & Reeve as a partner in the family team and is head of the children practice. She's named as a leading individual by renowned legal directories, as she specialises exclusively in family law and is renowned for her particular expertise in representing children in proceedings. She's known for handling complex matters, and so she is used to working with all sorts of cases which involve very serious aspects. She has experience dealing with child abduction, relocation, wardship, special guardianship and adoption, including inter-country adoption and Hague inter-country adoptions. Zoe's memorable moment of 2020, and I love this, was getting a speedboat ride back to shore in Ullswater, that's in the Lake District, not in the boat, but hanging on to the side of the boat due to social distancing. We'll remember these things the rest of our lives. So Zoe, tell us a bit more about children.
Okay. In contrast to everyone who's gone before me, perhaps save for Magda, saying it's going to be really complicated, I want to be really positive and say, well, actually, it's simplified as far as child abduction is concerned. We've got one less piece of law to look at for UK child abductions. So yes, I'm going to talk about child abduction and what changes when the UK leaves the EU. Okay, so it's not going to be a deep dive, but I am going to cover some basics. So child abduction is the wrongful removal to or wrongful retention of a child in another jurisdiction in breach of rights of custody. So once you have established there's been a child abduction or a retention has occurred, you need to ask from what country and what is the relevant piece of legislation. Now, where we are in 2020, we have 4 groups. In 2021, we'll have 3 groups. So the 4 groups we currently have are those countries who've signed the 1980 Hague Convention on civil aspects of international child abduction, which was brought into force in England and Wales by the Child Abduction and Custody Act 1985. So the 1980 Hague Convention signatories include most of Europe. There's a clue. North America, Australasia, large parts of Africa, some countries in Asia and some in South America. The second group are signatories to Brussels II Revised, which includes most of Europe. The third group are signatories to the 1996 Hague Convention on Jurisdiction, Applicable Law, Recognition, Enforcement and Cooperation in respect of parental responsibility and the means of protection of the child. So signatories to the 96 Hague Convention are Albania, Denmark, Morocco, Switzerland and Tunisia. The fourth group is everywhere else in the world, which includes the Indian subcontinent and most Sharia countries, where none of those, either the 1980 or the 96 Convention or Brussels II Revised, applied. So the most appropriate recourse for the return of a child would be inherent jurisdiction and wardship, but you need to remember some bilateral treaties such as the Pakistani Protocol or the Cairo Agreement. And of course, remember, for child abduction proceedings, Interpol, the police and criminal proceedings are often appropriate. Okay, so what does it mean that we will no longer be able to use Brussels II Revised? Well, we'll lose those group who are signed up to Brussels II Revised, but that's okay because we've still got the 1980 Hague Convention on Child Abduction. So my messages will be okay. I do want to highlight just 3 features which we're going to lose when we lose Brussels II Revised. They're not the only features we're going to lose, but for the purposes of my 8 minutes, I can't talk about all features. So at the moment under Brussels II Revised, the 6-week period for determination for a decision as to whether a child is to be returned to the place of habitual residence is 6 weeks, which is very swift. But so that is a loss. However, Article 11 of the 1980 Hague Convention says if a judicial or administrative authority has not reached a decision within 6 weeks from the date of commencement of proceedings, the applicant or the central authority of the requesting state has the right to request a statement of reasons for the delay. So there's something that replaces that. The second feature which we're going to lose is Article 11 of Brussels II Revised contains a trumping provision which gives the original court the power to order a return, i.e. a second bite of the cherry. So if the originating country is not happy with the non-return order, they can request another review of that. There's a detailed criteria as to when you can use that trumping provision, which I'm not going to go into just at this moment. The third feature we're going to lose, under Brussels II Revised, Article 13b defence that a child should not be returned where there is a grave risk of harm doesn't apply under Brussels II Revised. Just to explain why, for example, you've got an abduction from Spain, France or Germany, obviously you can't say, well, there'll be domestic abuse when the child's returned to that country, because obviously that country will have protective measures that can be in place. So those are 3 features which will be a loss, but it's okay. We do have the 1980 Hague Convention providing similar features. So I say, don't worry, don't panic. We can still proceed and get children back, whether it's an outgoing or ingoing child abduction. So it remains the case that child abduction litigation is strictly jurisdictional. It's based on the habitual residence of the child, and it's not really related to welfare or nationality. So the case of Reesey, a 2018 UK Supreme Court case, says habitual residence is where the child's centre of interest is. It's a factual inquiry. That won't change when the UK leaves the EU. There is more case law on the issue of habitual residence than, as far as I'm aware of, on any other family law concept. But I don't think that the UK leaving the EU is going to create difficulties for what is a long line of settled law. Habitual residence is a concept that's developed through Brussels II Revised cases, Hague 1980 cases, inherent jurisdiction cases. We will still know what we're doing. So apart from saying don't worry, I do have something important to say. In terms of recognition and enforcement of access orders, so contact orders, you do need to be aware that under Brussels II, access orders like return orders have immediate recognition and enforcement without the necessity of any intervening exequatur. So in contrast, the 1996 Hague will require a declaration of enforceability, Article 26, which will slow down enforcement of contact. So that could be detrimental to a child's relationship with the left behind parent. So that is something to flag up, that lack of automatic recognition and enforcement. I'm not going to talk about transitional provisions within this time period. Have I got 1 more minute, Suzanne, just to talk?
You have 1 more minute.
Thank you. So whilst I'm being terribly positive in terms of child abduction litigation, whilst expressing remorse for our departure from the EU, I can say something very positive about the UK in terms of domestic abuse. So the EU introduced various cross-border laws committed to continuing to recognise and enforce incoming domestic protection orders. So the UK, well done us, have committed to continuing to recognise and enforce incoming domestic protection orders. Exceptionally, the UK has done this by retaining EU law within national law. So great for the UK. However, despite requests, the EU has sadly not reciprocated yet. So victims of domestic abuse in the UK seeking to have protection orders obtained in the UK, enforceable in the EU, will need to commence separate proceedings in the EU member state in which the perpetrator is based for enforcement purposes. There's been some case law already which can demonstrate how this will happen. So that's, I was hoping to end on a high, but actually that's a negative note, because the outgoing orders, we will need to make sure that something is in place if there's domestic abuse.
Don't worry, Zoe, because I'm pretty sure that Michelle Barnier is listening to us and thinking about any of the gaps that need to be plugged from our webinar. So I'm sure that's absolutely fine. I just wanted to now turn to some questions which have come in. First of all, Rahima, just saying that London has always been known, or for some time has been known, as the divorce capital of the world. I think we took over from New York. Do you think that will change at all after Brexit?
I don't think it will change. UK will be considered as New York. UK judgment of divorce will be considered as a New York judgment, or as another country judgment. And I don't think it will change, because we would still have first the race of jurisdiction, and we will still have cases in which we would still apply UK law. So I don't want to depress you guys, but unless all the very rich people of the UK leaves the UK, I don't think the reason why we won't consider the UK as New York as being one of the capital divorce of the world.
Yes, because we'll retain our discretionary system, which I think is really what pushes that sort of title. Daniel, did you want to say anything?
No, I don't see that changing. In many ways, it's going to be easier to bring your claim in England. So I don't see that changing. And where money's involved, people are prepared to fight, aren't they? So it will just be another layer of the fight that wasn't there before. But I don't think it will change it at all.
Yeah. And Gretchen, what are your 3 top tips, if you can think of 3, for dealing with separating international couples from 2021 onwards?
My 3 top tips. Okay, I think the first tip is to be flexible. We're seeing now that it's taking a lot of time to process divorce actions, so keep your mind open to alternative methods of resolution, such as ADR, mediation, perhaps. My second top tip would be, if you're considering divorce, also consider the financial climate and your industry and whether now is a good time. And my third top tip, let's see, what's a good one? I think, honestly, I've seen a little bit of panic in terms of litigants trying to roll over to a virtual system. So if you really are going forward, I would say expand your knowledge and use of technology, because I think that's going to be a very big part of the future. And there's nothing worse than worrying about whether your webcam is working as opposed to the substance of what's happening in a proceeding. So I think that a little primer for all the divorcing couples who are going through this right now is helpful and necessary.
Brilliant. And Daniel, have you got any other top tips?
I think I would just reinforce some of the things I said before, which is that I think it's going to be absolutely crucial that people take that advice much earlier and in much more depth than they did before. I think that's the key thing to think about. Unfortunately, I still think it requires people to act quickly and unfortunately be secretive. I think it does require an element of surprise and getting in there first. So I think that's still very much the case.
And so possibly not going to dispute resolution start off with.
Well, I think that is a positive thing. I think it is going to open up the opportunity for more mediation and arbitration once those issues have been resolved, because people are going to have a forum battle potentially. Yeah. So that is something I think people should mediate and arbitrate about. So I do think there probably is some positive side of that.
And Suzanne, if I could mention too, at least in New York, it's not mutually exclusive. So a lot of times we will file just to preserve the jurisdiction, and then we can enter into a mediation or arbitration situation.
And that's the difference, Gretchen, because now it is mutually exclusive, because if you've won, you won, and you don't need to be nice or have a discussion or debate about it or try and resolve it, because you won the battle. So I think that actually that part, it will lead to more mediation and other dispute resolution models.
Which is great. And Zoe, are there any other silver linings from the Brexit cloud, or have you mentioned them all?
Well, I want to put this in a sensitive and thoughtful way, but I think there's still lots more scope for case law on the issue of habitual residence. I mean, I think the UK's departure from the EU, the pandemic, it just brings ever more arguments, lawyers who don't need more arguments about whether roots have been put down or roots have been pulled up. But I think this whole year and the circumstances will, I'm afraid, family law litigation will just continue. You said positives and opportunities. Lots of positive and opportunities for legal arguments. I mean, I would like to be positive in terms of the families for the way, the UK has dealt with recognition of incoming domestic protection orders. So that's very positive. There's lots of opportunities for more drafting of laws, though. There's, there are lacunas and things we've lost through Brussels too. We could have more laws introduced to remedy those losses. So there's lots of opportunities. Yeah.
Yes, I think a positive for me, which is a sort of byproduct, is that I'm sure we're going to be spending even more time together with lots of foreign lawyers trying to work out what to do. And I really hope that we will do that in a very collaborative and cooperative way, notwithstanding our departure from the EU. So I suppose overall, I'm seeing that as a positive. And I think that's a good place to end, really, to say thank you very much for my brilliant panel today, hearing so much from across the world. And, Daniel and Zoe in England, Gretchen, New York, Rahima, Paris, and Magda in Switzerland. Absolutely fascinating to hear from all of you. Really grateful to you for taking part in this. And I think we just need to keep on staying as friendly as we are and keep moving forward. So thank you very much.
Thank you.
I think there's going to be a feedback form or something that may come up. If it does on your screens, please feel free to fill that in. And